Hi everyone, and welcome to this short session today on disciplinary and dismissal, your frequently asked questions and indeed frequently Googled questions. So joined today by Roy Magara from Magara Law. I am Zoe Lidster from Harwood HR Solutions. So firstly then, over to Roy for our first question. When should I start the disciplinary procedure?
Thank you very much, Zoe. So disciplinary action can start when you as the employer have concerns about, but not necessarily limited to, the employer's conduct or work or absence. So typically before taking any disciplinary action, it may be more appropriate to consider the matter informally with the particular staff member. In any event, ideally, you should have a disciplinary policy in place which outlines the procedure which you are going to take and that you're going to follow throughout the whole period, because what you'll want to show is that the employee has failed to meet any kind of standard or conduct or work or absence standards, as we just mentioned. So the policy should also contain examples, preferably of what may constitute, for example, as gross misconduct, so that there's some kind of threshold to work to, or some kind of unexpected behavior as well, which can be pointed to by line managers and other members of staff. The whole point of focusing on the disciplinary policy just in this moment in time is that it's important in order to establish a clear procedure for the company throughout that will be used in the event of such serious or repeated misconduct. And importantly, or more importantly in a sense, it also ensures consistency throughout.
Thanks, Roy.
Super. So next question, Zoe, is can I dismiss an employee during probation without providing a reason?
Yes, I think this is quite a common question because people think that, well, they're in probation, so I can just dismiss them. I don't have to tell them why. I don't have to hold any kind of meeting. I can just tell them to go. Not quite the case, and indeed definitely not the way to do things. So when dismissing an employee on probation, it's really important that you explain the reason to the employee. At the end of the day, you as the employer, the line manager, know the reason why you no longer want the employee in the organisation. So it's only fair to tell them that, right? Also may help them in the future with their next role as to not make the same mistakes. So it's, and you know, they are an employee of yours. It's important to sit them down and really explain those reasons to them. Why wouldn't we want to share them? Although during the probation period, the employee doesn't have a right to appeal, again, I think it's probably best practice to give them that right. So make sure that you invite them to a probation review meeting. You give them the right to be accompanied to that meeting. You sit them down in the meeting and clearly explain the reasons where they're for their dismissal and why their performance hasn't met the required standard. And then afterwards, you know, confirm that in writing to them, give them the right to appeal. This allows you then just to close down any potential issues before they arise.
Thank you.
So our next question then, how do I legally dismiss an employee?
Well, in law, there are 5 reasons for dismissal, which Zoe is actually going to touch on next in the next FAQ. But for now, just take note of these practical steps that you can take in order to at least ensure that you legally dismiss the employee. So first things first, follow the relevant procedure. Secondly, take notes and investigate. And thoroughly, you'd be surprised how many notes are taken and they're just not adequate enough for the circumstances. And it's very easy then for the disgruntled employee to pick holes in that argument or say that something is in there that wasn't, something ought to be in there that wasn't in there at the time, contemporaneously. Next, take care not to discriminate against anyone. So whether that is, well, probably not consciously, but certainly be aware of things like unconscious bias or subconscious bias with various people. Because what you ought not to want is for there to be some kind of gender or race or otherwise discrimination claim involved with that particular process. Next, invite the employee to a disciplinary meeting. Always make sure and remember that at least as far as today is concerned, they ought to be allowed to either bring a colleague or a trade union representative to that. It's typically discretionary in terms of whether the company will allow anyone outside that scope, for example, family member or legal representative or otherwise. But always make sure that minutes are taken of these meetings. Next, make sure you reach your decision in a reasoned fashion, and always ensure that that outcome is communicated to the particular employee, and make sure that it's followed up in writing as soon as reasonably practicable. It's really important to remember. Next, remind the employee and outline to the employee that they are entitled to an appeal. And that appeal, again, they're entitled to have either a colleague or a trade union representative, at least as far as today's webinar is concerned. That might change in the future. Again, it's open to the company as to whether you want them to have, or you allow them to have rather, a friend, family member, legal representative, or other third party. But I think what's really important to note, as far as all of your cases or matters are concerned, make sure there is consistency. Those are some examples of how you can legally dismiss an employee. Moving on to the next question, as hinted at earlier. Zoe, on what grounds can an employee be dismissed?
Okay, so as you already mentioned, there's 5 potential reasons for dismissing someone fairly. So the first one is conduct. So this is where the employee has done something that's inappropriate, not acceptable. They've behaved in a way maybe that is not appropriate. Next one is capability. So this is where the employee is not able to do their job. So things like performance, sometimes sickness absence will fall into capability as well. Redundancy, the role is no longer required. And just that, the role is no longer required, not the individual. A legal reason, so the employee can't now legally do their job for some reason, i.e. maybe a lorry driver gets banned from driving, perhaps they are fined for drink driving. They no longer then have the right to be able to, they longer then can continue to do their job because they no longer have the license required. Maybe the employee, their status changed and they no longer have the right to work in the UK. That could be a fair legal reason for their dismissal. And then finally is some other substantial reason. So this is used in a variety of different situations. For example, maybe where a client refuses to work with that employee now, and then you no longer have any alternative employment for them. So yeah, you have no alternative but to dismiss them. Maybe a significant relationship breakdown between perhaps the employee and maybe senior management. That also may constitute for some other substantial reason. Okay.
Yeah, really good points.
Roy, when is it more appropriate to consider conduct as a matter of capability rather than disciplinary, or vice versa?
Thank you. So there are certain sometimes instances where a situation happens at work or in a sort of capacity of work with an employee where there's a gap in understanding rather than an actual misconduct issue. And too often employers see gaps in understanding as misconduct issues, as opposed to ensuring that their staff are well trained or indeed retrained adequately in order to encourage them to do the job that they're set out to do. Or sometimes employers take a sort of knee-jerk reaction and sanction the employee instead of ensuring that the employee has got better guidance in the future. So in that kind of scenario, that would certainly be more of a capability issue, as opposed to, conversely, the times where there's conduct that shows a poor or genuine disregard for any of the company's policies or procedures. And Zoe, you've outlined a couple of those examples in your 5 reasons earlier. So in these instances, that's where the disciplinary procedures ought to be followed, as opposed to capability procedures. Okay. So Zoe, over back to you. How do I dismiss an employee for poor performance?
Yeah, well, the key to this is planning and timing, as it really should only happen after some sort of performance plan, training, coach and support has already been provided. And then you will be moving through the warning process. So where there are conduct issues, perhaps that are a contributing factor to the issues with performance, i.e. things like maybe consistent lateness, meaning that they're missing vital information that's perhaps always given out in a morning meeting, or they've missed, some of the, maybe they miss training because they're absent from work too often, something along those lines. You might need to look into that and rely on this as perhaps a more effective way to exit your employee sooner, if that's what you're looking for. Really, otherwise though, managing performance targets should be set. So you need to be putting them on a performance improvement plan. Those targets need to be achievable, they need to be measurable, and you need to give the support to the employee to help them achieve those targets. So they should be set as corrective action as opposed to trying to manage them out of the business. However, you don't need to set lengthy periods for review. So maybe minimum of 2 weeks, maximum maybe of 4 weeks, dependent on the targets that you're setting, of course. It's again, you need to be able to allow the employee to achieve those targets. So it needs to be reasonable. At the end of each of those periods, you need to sit down with the employee, review their performance and help them understand where they are in terms of what standards you've set and that you required, and how are they doing against how are they measuring against those targets that you've set. But at the end of each stage, if the employee then hasn't achieved that plan, that's when you can then sit down and go through that formal procedure with them and potentially issue a warning. So you can move through this process relatively quickly, but you do need to be seen to be being fair to the employee. But you could, for example, have 2 to 4 week plans where you sit down at the end of each one, they haven't met the plan, and you move them through to the next stage of the warning. These things, though, can often be resolved informally in the early stages. So just by having a conversation with the individual, don't wait months down the line to then decide to tell them that actually they're not performing well enough. You've then, made the process harder for yourself as well, because time has gone on, and you've let that snowball. Address it early on, use probationary periods to manage people into the business effectively or out if they're not going to hit the required standards. But also, by sitting down with that individual early on, having the conversations, there might be mitigating factors that you need to consider, such as some serious issues at home, meant their mind hasn't been quite on the job. So, there might be a reason why they're not performing as you'd hoped. Perhaps they're not actually enjoying the role. So when you have that informal chat with them early on, you actually take a bit of a weight off their shoulders and you help them to realise that it's not the role for them. And maybe they make their own decisions and leave the business. So it's just really important. Communication. We say this all the time when we have these sessions, but yeah, just take time out early on, sit down with them, and if not, put a nice effective improvement plan in place.
Communication indeed.
Okay. So Roy, how long does a written warning last for?
Well, a written warning, that will depend on the company policy and sanction, generally around 6 to 12 months, typically 6 months for a verbal warning, and 12 months for a written warning. I think the important thing is just to make sure that the employee is aware in writing as to how long it is going to be kept on file for, both in the outcome letter and in the company policy.
Okay, thank you.
One thing
I may have skipped on a little too quickly and overlooked a question here, so I do apologise.
Sure.
We'll jump back to that one. And yeah, can an employee be dismissed without a disciplinary hearing if they've got less than 2 years service? So short answer to that is no. There is a general misconception about this, and it always lands the employer in hot water. This is because employers believe that employees with under 2 years service can't bring any claims against them. Well, in actual fact, there are a number of financially, PR and staff morale crippling claims that can be brought against companies by disgruntled employees with under 2 years service. So no, it's really important. Always follow that disciplinary procedure, invite them to the hearing, give them the right to be accompanied and the right to appeal the outcome. That will allow you hopefully to legally dismiss your employee without any issues.
Yeah.
So there you go. So yeah, apologies for jumping ahead.
Sure.
But yeah, obviously, we hope that these questions have been really helpful today. So if there is anything else that you'd like to know, or if you'd like to discuss any of those with us in any more detail, please feel free to give either of us a shout. We're always happy to have a quick chat for free, absolutely no problem at all. And we will speak to you again very soon. Thanks, then.
Thank you, Zoe.